All right, let us begin our discussion on what is a due diligence, right? In this section, we'll be talking about what a due diligence is, why we should be doing a due diligence, what kind of documentation do we look at, and what is it that we're looking for. Now, to understand what is a due diligence, it's fairly simple in layman's terms. We consider it a legal audit of the company, or some may consider a super audit of the company. While an audit of a company, whether it's by lawyers or by accountants, simply will tell you what the risks are, in a legal due diligence, we go deeper into it and try to find out how those risks can be removed. It is defined as such a measure of prudence, activity, or assiduity as is properly to be expected and ordinarily exercised by a reasonable and prudent man under the particular circumstances, not measured by any absolute standard, but depending upon the relative aspects of the special case. In other words, the role of an M&A lawyer is to minimize risk for the transaction, is to ensure that any risks that have come up in the company prior to the investor coming in, that the investor is adequately protected from those risks, which makes the due diligence extremely important, right? Now, for example, let's say the company is involved in a tax litigation, which is quite the par for many companies. Now, if something had gone wrong with the company before the investor had invested, and as a result, there are now tax proceedings against the company, the investor should not be expected to take on that risk. In case the courts hold the tax litigation against the company would run a loss. The investor ought to be protected against such a loss unless if the investor himself agrees. So this is effectively a process by which we discover the risks in a company, right? We have discussed in depth why we should do a due diligence, primarily because shares are goods as defined under the Sale of Goods Act. Also under the Sale of Goods Act, Section 16, there are no implied conditions as to the quality or fitness of goods. This leads to a Latin adage that we know as caveat emptor, that goods once sold cannot be returned unless if a condition is not met. Recall our discussions on basic contract law and especially the Sale of Goods Act, where we discussed that if you have a contract which is then not met, a stipulation which is a condition which is not met, you will not be able to return the goods, you will not be able to cancel the contract. You're able to cancel the contract only if a condition isn't met. We also can't claim for specific damages unless specific representation or warranties are made in this regard. Therefore, a due diligence will be able to help you understand and then find out what are the conditions, representations, and warranties that ought to be expressly made by the seller of the goods, in this case, the company and the promoter together. So in other words, what we're trying to do is ensure that the investor or the buyer of these goods has some recourse to justice in case there is something wrong with the goods itself. Now, don't get me wrong, there's probably nothing wrong with the shares themselves. But the value of the shares doesn't come from the abstract idea of a unit of ownership. The value of the shares comes from the underlying company, right? And the shares represent part ownership of that company. And therefore, it is important for us to figure out whether those shares and therefore the underlying company are defective in any manner. A due diligence is nothing but discovering those defects in a company prior to investing in it. Now, the process is fairly simple. Whenever there is a due diligence that has to be started, M&A lawyers will usually send a document checklist in advance, right? Now, this checklist depends upon which lawyer you're working with or which law firm you're working with. Different law firms have different checklists, right? So I used one checklist that I used from my Fox Mandal days, which was then changed over time, right? Depending upon new developments in the law, new requirements for the diligence process. Now, this document checklist is nothing but a list of documents that the due diligence lawyer will require to review with the company, right? Now, these are corporate documents. They ought to be with the company, and they should be willing and able to provide these documents at any given point of time. Now, earlier on, what used to happen was that M&A lawyers would physically go to a company, to the company's headquarters, sit there and stay there for a couple of weeks, perhaps a month, perhaps a few months, depending upon the size of the company and the complexity of the deal. While they're there in the company's headquarters or the registered office, they're reviewing these documents one by one. And every document must be reviewed. Now, these documents could go into the hundreds, perhaps the thousands, which is why it takes a lot of time to actually do a proper diligence. Nowadays, what's happening is that companies prefer to upload these documents onto a data server. And the M&A lawyer is then able to access these documents on the server itself. Now, once we are reviewing these documents, there might be discrepancies, there might be deficiencies that might crop up. What these deficiencies and discrepancies are, we'll be discussing in more detail later on. But at this point of time, at the moment there is any discrepancy or any deficiency in the document itself, M&A lawyers typically make a note of that and raise a red flag. These red flags or these issues are then raised with the target company. Once the target company once we discuss this with the target company, there may be a valid reason or a valid explanation for this, right? If this has been adequately explained, if the deficiency has been adequately explained, we may consider removing this issue. However, in most situations, these issues that crop up, these risks that crop up, will not be adequately issued. Now, it is then for us to decide, as M&A lawyers, to decide whether a particular red flag or an issue or a risk is to be covered under conditions. Is it to be covered under conditions precedent or subsequent, or is it to be covered under representations and warranties? Now, how we determine this is the level of risk. Now, many different people have different ideas on what constitutes level of risk. The most high risk issues that come up are typically placed in the conditions precedent section of the shareholders agreement, of the share subscription agreement. Something a little less riskier could be placed in the condition subsequent. Less riskier than that in the representations or warranties or even covenants.